The president of Shiv Sena, Uddhav Thackeray, had publicly and admittedly not aligned supported the BJP. In these circumstances, the satisfaction of the governor for the purpose of calling respondent 4 to be the chief minister as the head of 39 rebel MLAs of the Shiv Sena, which is endorsed by the Shiv Sena political party, is by itself ex facia unconstitutional. The Constitution prohibits recognition of rebel MLAs of a political party under the 10th schedule, and the action of the governor legitimizes what is expressly prohibited by the Constitution. The governor has sought to recognize what the Constitution prohibits. The governor is also not empowered under law to recognize who is the Shiv Sena. That is the domain of the Election Commission. Admittedly, recognition of the Shiv Sena and its leadership by Uddhav Thackeray has been endorsed by the Election Commission, and there was no dispute whatever or challenge before the appropriate authority on the 30th of June. There was no petition before the Election Commission on the 30th of June. That was filed only on the 19th of July. The Uddhav Thackeray was the chief minister of the Shiv Sena. So in what capacity did the governor, Maharaj, give an audience to Eknath Shinde and administered the oath of office to him? How is that the discretion of the governor to do that? Which party was the governor, Maharaj, recognizing for the purposes of forming the government with the support of the BJP? That's, Maharaj, that's the heart of the matter, and that's nothing to do with the power of the speaker now, Maharaj. This is an independent challenge, Maharaj, on the appointment of Eknath Shinde as chief minister by the governor, and the act of the governor is subject to judicial review. In these circumstances, the governor, in his ipsit dixit, guided by his political masters in mala fide, and in the teeth of the provisions of the Constitution, granted a de facto. What it does, Maharaj, what paragraph 3, when paragraph 3 is deleted, the governor by his action recognizes paragraph 3. He recognizes the split. This is not a stage where the government is to be formed. This is a stage when an elected government is running. So your lordships for the first time will have to decide what are the discretionary powers of the governor in that context, and can his discretion be used to topple a government with respect to a set of people who say they are split from the Shiv Sena, when a Shiv Sena chief minister is already in place and the governor does not ask the Shiv Sena leader as to whether you are endorsing this or not. By not asking the Shiv Sena, he is recognizing a split. No, there is no discretion after the elected government is formed. The government then will fall, Maharaj, on the floor of the House. Then the question of the discretion of the governor will come in. If there's a no confidence motion, government falls, then the question will come in as to who the governor will fall. But the governor cannot by his act topple the government. No, the question is not that. When Maharaj, the governor was approached, when the governor was approached by BJP as well as Eknath Shinde, and the governor told us to have a trust vote, Maharaj, on what basis did he ask us to do that? He obviously recognized the 39, otherwise he wouldn't have asked us for a trust vote. There was no occasion to. Because they continue to be in the Shiv Sena. That's their own case. That they did not, Maharaj, move away from the Shiv Sena. So if they did not move away from the Shiv Sena, which is their own case, on what basis did the governor say you have a trust vote? Unless he recognizes that the 39 members are rebels, they have split from the Shiv Sena, therefore they and BJP have a majority, therefore you go and show your majority in the House and have a trust vote. That is, well, it's logical. That's the only way to look at it. And the governor must act consistent with constitutional morality. What's the moral foundation of such an act? I have already said deletion of paragraph 3. I don't have to read. Of course, it's a principle of constitutional morality. Well, then I want to just note the page, Maharaj, in Nabam Rebia at page 1145. 1144. Paragraph 210, Maharaj. Just note that. Para 210. Don't mistake the book, but just note that. I'll just read it. Last 4 lines, Maharaj, of that paragraph. Admittedly, the governor never called for a floor test, nor did he ever require the chief minister to establish his majority in the House. The governor's actions based on feuds and wrangles of a breakaway group which is not recognized under the 10th schedule cannot be constitutionally condescended.
What was the last sentence? The governor's?
I just read it again. Admittedly, the governor never called for a floor test, nor did he ever require the chief minister to establish his majority in the House. The governor's actions based on feuds and wrangles of a breakaway group which is not recognized under the 10th schedule cannot be constitutionally condescended. It's directly on point. Because the governor, by asking me to go for a floor test, having a trust vote, has condescended to recognize a breakaway group, expressly prohibited and the governor's action struck down in Nabam Rebia. So we don't have to go into the issue whether the matter should be sent back to the speaker or not. If you decide this issue, the matter is, nothing else is required to be decided. So we challenge the trust vote. We challenge the action of the governor to swear him in as chief minister. If that goes, everything else goes. Then we don't have to go into the problematic issue of sending disqualifications back to the speaker. And ultimately, Malaj, the facts are so crystal clear that they can't be the subject of yet another interpretation. They can't be, Malaj. The Constitution doesn't give him that power. The 10th schedule, he is far away, far removed from him. Para 3 has been deleted. Breakaway groups can't be recognized by that way, Malaj, every day a breakaway group will be recognized by the governor and governments will fall. I don't think, Malaj, the Republic expected this. And our Constitution, Malaj, ever envisaged a situation that can happen in our constitutional democracy. The whole integrity of the political process comes to naught.
Rameshwar says.
Nabam says the 3 areas in which the governor has discretion, beyond that, none. 371, Article 200, and Muller's forming a government at the initial stage after an election. There is no discretion with the governor. He acts otherwise on the aid and advice of the Council of Ministers. That's settled law. And of course, 356, Mullahs, sending a report to the central government. That's not something on the aid and advice because, so 356, 200, and 371. These are the three areas.